Hello everyone, I'm Debojit Das and you're watching Courts Today by LiveLaw, your daily rundown of the biggest updates from India's courts. From elections and air safety to stray dogs and right to clean air, the docket is packed. So let's begin. We'll start with the Supreme Court as we usually do, where this case arose where a former councillor failed to disclose her prior conviction, a 1-year imprisonment for a check dishonor offence, in her election affidavit. The court held that hiding such a conviction is suppression of material information, which violates voters' rights to make informed choices. Crucially, the court emphasized that it doesn't matter whether the non-disclosure actually changed the outcome of the election or not. Once a candidate fails to disclose their conviction, the election becomes void under the law. The bench of Justices P.S. Narasimha and A.S. Chandorkar made clear that the offence of non-disclosure triggers invalidation of the returned candidate's election because the nomination form was improperly accepted. In short, candidates must truthfully disclose past convictions in their affidavits. Failing that, even if we cannot prove the election result was unfair, simply hiding the conviction renders the election null. Staying with the Supreme Court for this one, as it issued an interim order saying that for now, no motor accident compensation claim should be rejected purely because it is time barred under Section 166, subsection 3 of the Act. So what exactly happened here? When Section 166(3) was introduced via the Motor Vehicles Amendment Act of 2019 that became effective from 1st April 2022, it says, no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. Claimants argued that this 6-month deadline undermines the very purpose of the Act, which is to provide relief to accident victims. The Supreme Court agreed that the issue is serious and affects many pending petitions, so it directed all motor accidents claims tribunals and high courts not to dismiss claims on limitation grounds until the full hearing is done. In practical terms, even if a claim is filed after 6 months, it cannot be thrown out right now. The court asked parties to complete pleadings urgently, next hearing is on 25th November, and expedited the matter. So why is it important here? It recognizes that victims of accidents often face delays, that is medical treatment, investigation, or due to documentation, and that setting a strict 6-month limit might defeat the cause of compensation. The court is treating the Act as a benevolent legislation and wants caution in denying claims merely for missing a timeline. So until the Supreme Court gives a final decision, do not assume your motor accident claim is dead just because it was filed late. Tribunals should give them a hearing, not dismiss them outright under Section 166(3). Next, the Supreme Court took note of the alarming rise in dog bite incidents and decided that stray dogs must be removed from places like schools, hospitals, bus stands, railway stations, even public sports complexes and government depots. A 3-judge bench of Justices Vikram Nath, Sandeep Mehta and N.V. Anjaria ordered that local government bodies must fence these institutional premises to prevent stray dog entry. The order further directs that stray dogs picked up from these zones should be vaccinated, sterilized in accordance with the animal birth control rules, shifted to designated shelters and not released back into the same spot. The court said that releasing them back would defeat the purpose. After the order was announced, some senior advocates attempted to make submissions, arguing that if the dogs are removed, new ones will take their place. The bench refused to entertain those submissions and signed the order anyway. Additionally, the court extended directions to remove stray cattle and other animals from highways and public roads, requiring joint coordinated drives, helpline numbers along expressways, and holding field-level officers personally accountable for lapses. Moving on to another hearing in the Supreme Court today regarding a plea filed by Pushkar Raj Sabharwal, the 91-year-old father of Air India pilot Captain Sumit Sabharwal, who lost his life in the Ahmedabad plane crash earlier this year. He has sought an independent judicial probe into the incident, arguing that the ongoing investigation by the Aircraft Accident Investigation Bureau lacks impartiality and transparency. The crash of the Air India Boeing 7878 Dreamliner in June 2025 had killed 260 people shortly after takeoff from Ahmedabad, triggering widespread calls for accountability. During the hearing, a bench of Justices Suryakant and Joymalia Bagchi made it clear that the pilot should not be blamed for the tragedy. Nobody can blame him for anything, Justice Kant said, pointing out that neither the preliminary report nor any official record suggests pilot error. The bench also took note of the speculative foreign media reports accusing the pilot of negligence and described them as nasty reporting, saying such narratives cannot determine the outcome of the investigation. The court has issued notices to the Union Government, the Directorate General of Civil Aviation and other authorities, seeking their response on the request for a judicially monitored probe. It underlined the importance of a fair and credible investigation, free from bias and speculation, to ensure accountability in one of India's most devastating air tragedies. In essence, the Supreme Court has reassured the family that the late pilot's reputation will be protected while the truth behind the crash is thoroughly examined. Next, we saw the Supreme Court reopening the CBI's appeal against the acquittal of Ajit Jogi, son of former Chhattisgarh Chief Minister Ajit Jogi, in the 2003 murder of NCP leader Ram Avatar Jaggi. Jaggi was shot dead in Raipur, and though a trial court acquitted Ajit Jogi and others in 2007, the CBI, the state, and the complainant all challenged that verdict. The Chhattisgarh High Court had earlier dismissed the CBI's plea as delayed and rejected the others as non-maintainable. But the Supreme Court has now stepped in, ruling that such serious allegations cannot be thrown out on technical grounds. The bench held that procedural delay should not override the need for justice in a murder and conspiracy case. At the same time, the court refused to restore the state and complainant's appeals. It said the state cannot appeal under Section 378 of the CRPC when the case is investigated by the CBI, and the complainant had no such right before the 2009 amendment to that law. In a notable move, the Supreme Court also allowed Ajit Jogi to be heard even at this early stage, ensuring fairness and transparency as the CBI's revived appeal now goes back to the Chhattisgarh High Court for a fresh hearing. Moving on from the Supreme Court to the engineer Rashid case in the Delhi High Court, which has produced a split verdict over whether the cost condition imposed on him to attend Parliament while in custody is valid. Rashid, a member of parliament from Baramulla elected in 2024, has been jailed since 2019 under the Unlawful Activities Prevention Act. A trial court condition granted his custody parole for parliament attendance only if he deposited roughly 4 lakh rupees with the jail authorities. In the division bench hearing, Justice Vivek Chaudhary rejected Rashid's plea against the cost condition, while Justice Anup Jairam Bhampani allowed it, creating the split. The dispute centers on whether the cost includes allowances like police salaries, meal expenses, and other escort-related outlays. Rashid's counsel argued that he cannot shoulder such heavy costs when he has not even been released on bail and remains in custody. Because of the disagreement between the two judges, the case has been referred to the Chief Justice's bench for final adjudication. Next, in an interesting ruling, the Civil Bar Association in Basti had approached the court seeking a writ directing the state of Uttar Pradesh to pay both past and future electricity bills for the Bar Association building located inside the district court premises. The association argued that since advocates are officers of the court, the state must cover these utility costs. However, the bench of Justices Soumitra Dayal Singh and Indrajit Shukla disagreed. The court held that there is no statutory duty on the state to pay the electricity dues of bar associations. The mere fact that advocates serve as officers of the court does not translate into the state bearing the costs of the facilities used by the bar association. The court added that while it recognized the role and contribution of lawyers, the bar association remains a body of private practitioners. Therefore, it must be responsible for the utility costs of the building it uses. The petition was dismissed, but the association was allowed to approach the state government separately or make payment arrangements. And for our final story, we look at a bench of Justices Revati Mohita Dere and Sandesh Patil that slammed a police officer from Matunga Police Station, Mumbai, for issuing at least 6 notices to 2 advocates in a senior citizen case, trying to compel them to reveal what their client had told them. The court said that such intimidation is unacceptable and that lawyer-client communication is privileged. The judges asked why the officer thought he could demand details of what was discussed between the client and his lawyers. They warned that if this kind of harassment continues, advocates may stop taking up indigent clients, harming justice. The court emphasized that police must be independent, fair, and cannot side with one party over another by targeting the lawyer. As a penalty, the court imposed a cost of 25,000 rupees on the officer to be paid from his own pocket and directed the state to distribute a copy of the relevant Supreme Court judgment on lawyer summons to all police levels to prevent repeats. And that's a wrap for Courts Today, but remember, to access detailed coverage of these stories and more, visit livelaw.in and keep following us on all our socials to stay updated with everything that is law. I'm Debojit Das. Thank you for watching.